Welcome to the Exchange Chambers podcast. This is one in a series. We're recording this on the 13th of June, 2024. My name is Louis Browne, King's Counsel.
And I'm Sara Sutherland.
We are barristers in Exchange Chambers, Manchester, Liverpool and Leeds. And can we thank you for listening to this podcast. We welcome feedback on it. We're going to talk today about a recent pre-inquest review hearing, a PIR, which Sara attended on Monday of this week. And we're going to talk about the case itself. We won't identify the name of the deceased or any of the properly interested persons, IPs, but we will talk about the issues which arose, and we'll talk about the learning that can be taken from this particular case, and also planning for and appearing at pre-inquest review hearings. How should you approach that? How should you approach questions of evidence and the like? So I'm going to begin, Sara, if I may please, by just asking you to tell us a little bit about the lady who died, her pre-morbid conditions and her cause of death.
Yeah, so this was a lady in her 50s. She had a history of breast cancer, and I'll tell you a little bit more about that in a minute. She'd faced a litany of problems with her kidney, and she had died, the pathologist said, as a result of hypertensive heart disease. The mechanism of death said to be a fatal arrhythmia, which is a little bit of a surprise because there were no cardiac issues at all in her history, and many people in their 50s do have some heart disease. But the pathologist went on to say that he found a non-functioning kidney. Now, he put it far more technically than that, but effectively her left kidney was not working, and he said it contributed to the death more than minimally or trivially, as it would have caused disturbance in the biochemical balance of the blood and bodily fluids, which would have increased the risk of arrhythmic events. That's a really long way of effectively saying her kidney wasn't working and it contributed to the death. The complicating factor in this story is that there was a colorectal surgeon who had been involved in some of this lady's treatment as a result of the non-functioning kidney, but the colorectal doctor had said, absolutely not, I don't agree at all, and I think it was hypertensive heart disease that killed her, which you might think is straying slightly outside of their territory for a colorectal expert, but there we go.
Did the trust in this particular case carry out a serious incident review and prepare reports?
So they had done a good, thorough investigation. And when I say good and thorough, what I mean is they'd been through all of her medical records, and they had identified that, in fact, the breast cancer that she was found to have in 2022 had been missed on no less than 6 occasions over the preceding 3 years. She'd had a series of scans, and it had spread when it was discovered in 2022. Now, there was no evidence at all linking the breast cancer to her death, which is an important consideration because, of course, for the family, hearing that your loved one had breast cancer and that was missed on over many years, their view was, well, we want the coroner to investigate that. We want to understand how that was missed, and did that lead to the death as well?
Is it right that the trust's investigation concluded that if a renogram had been performed sooner, the function of the kidney may have been salvaged?
Yeah, absolutely. So that was the other part. They identified that there was a delay, or certainly when this poor lady she'd had a stent and she'd had a series of other procedures, and that was it had happened in September 21. Now, it was the family's view that by October 21 she should have undergone a renogram, which is essentially an examination to see whether the urine is draining properly. That had not been undertaken, and the trust accepted entirely that it should have been undertaken.
So the matter is referred to the coroner, and the coroner carries out an investigation. And for the purpose of the pre-inquest review, the coroner concerned circulated an agenda.
Yes.
And the issues on that agenda covered a number of areas. For example, firstly, who were the interested persons?
Yes.
Who were entitled to appear? So the family would be one, the trust would be another.
Yeah. The coroner questioned whether there were a series of surgeons involved in her care, and the coroner said, I have thought about them, but I don't consider that they are IPs. And she canvassed our view. I agree entirely, they're not IPs. But of course, anyone has, they can ask to be made an IP is a status.
And it's an important status of an interested person, because it confers rights.
Exactly.
It confers rights to receive disclosure.
Exactly.
A right to make representations, to appear.
Yeah.
And to question witnesses.
Yes, of course, because if you don't ask the questions and other parties do from their perspective, it can be very damaging.
Also on the agenda was the issue of whether the European Convention on Human Rights Article 2 applied to the investigation, and given the present state of the law in relation to deaths such as this, it's unsurprising she concluded that it did not.
Yeah, I mean, it has to be exceptional circumstances, doesn't it?
It wasn't engaged.
Yeah.
And so the other issues for consideration then were as to the scope of the inquest. What did the coroner say in relation to that?
Well, it is, I mean, entirely understandably, the family wanted the breast cancer aspect. And I thought, well, is there a PFD, so a prevention of future death consideration for the coroner? Because, of course, coroners are mandated to investigate whether they think there is a risk of a future death. But there was just no causative link. There was no evidence of it. Now, whether my solicitors go on and get evidence from an oncologist is a matter for them, but there was no evidence. So although I put it before the coroner, she's a very good coroner, and she said, no, I'm sorry, I understand why the family want that considered, but it's not appropriate. So she started from the point of urological investigations.
Yes. And we're going to talk a little bit about disclosure in a moment, but that was on the agenda, as was the issue of which witnesses were to be called, which witnesses were to be read or not read, and other issues such as venue, length of hearing, and the date of the hearing. Can we then talk a little bit about, please, what the approach was, what your approach was to the preparation for this pre-inquest review hearing, because it is a fundamental step. If things go wrong at a PIR, then whilst they can be changed if you have another PIR before the inquest itself, it can often set the tone.
Yes.
Bad decisions made at a PIR because, for example, inadequate preparation by one interested person or another can set the whole process off and lead to an outcome which can often be one which is unsatisfactory because it is the product of an inadequate investigation. How did the coroner deal with the issue of the conflict between the opinion of the pathologist and the opinion of the trust colorectal surgeon?
Your point on the preparation is a really important one, because quite often people turn up to PIRs and they're not prepared. Now, if you think about a case management conference or a CCMC, you'd turn up prepared to answer everything. So you should be doing the same in a PIR. And also, you want to know what you're asking the coroner. How far do you want the investigation to go? But on the point of the colorectal expert disagreeing with the pathologist, the trust made the submission, well, we want you, coroner, to send our colorectal expert statement to the pathologist to see what he thinks, because it may well change his mind, which I don't know what your views are, Lou, but as far as I'm concerned, that's wholly inappropriate. The purpose of an inquest is to investigate the facts, not to try and get it by the back door.
Yes, and it's well established that an inquest is not a trial. It's not a criminal trial. It's not a civil trial. There are no parties. There are no pleadings. It's the coroner's investigation.
Yeah.
And for him or her to conduct a full and fearless investigation into the facts. I agree. I think it would have been very inappropriate for the coroner to have directed that the pathologist consider the colorectal report, not just for the reason you gave, Sarah, which is an entirely valid reason, of course, but also because it's just a fundamentally different discipline.
Yeah. Exactly.
You're not comparing apples with apples by putting a report from a pathologist, from a colorectal surgeon to a pathologist.
Yeah.
The colorectal surgeon didn't carry out the post-mortem.
No.
And questioning the cause of death from an expert who is not of the correct discipline. I mean, I would go as far as to say that it had practically no worth, if any worth at all.
I agree.
And so do we assume then that the coroner was disinclined to
Yes.
allow that to...
Absolutely, she was.
To be done. So what now then, in terms of medical expert evidence? What has your submissions on that?
Well, it's an interesting, it flows from the difference between the colorectal and the pathologist, because of course we need a urology opinion. The coroner was not minded at this stage to get an expert opinion because there was still a potential witness. There had been urologists who had treated this lady, one of whom was a chap who had moved abroad to Dubai, was refusing to contact to maintain contact with the trust, which is a jurisdiction question, which I'm going to look to you for guidance in a minute. Insofar as the coroner told me, well, no, we're not getting an expert urologist. Well, I'd like to see, number one, the witness statements that the urologists originally provided to the SIR, so those indicating had input from urologists. Can we see it, please? And the coroner said yes. And the second avenue is to go to one of the treating urologists who the trust actually said during the course of the PIR, they said, well, we don't think he works anymore. But Google ably assisted, and he does work there. So I was able to give them his email address.
That's a fairly surprising point to take, isn't it?
It is.
He's still on the payroll.
I know.
And do you contemplate obtaining expert evidence to put before the coroner from a urologist when you have these documents, or when you see what the coroner chooses to do first?
That's a really interesting question, and I know it's something that troubles a lot of people. Do we, if we obtain a medical report, have to disclose it to the coroner?
My view would be yes.
Yes, which is you have to then think very carefully about what you're going to do. If you have evidence that's completely unhelpful in front of the coroner, in some respects, what have you got to lose investigating? Well, money.
Yes.
So you need the funding. But that's something that we need to think carefully about, because, of course, if you get to the end of an inquest and the conclusion is unhelpful, then potentially there is no case thereafter. The jurisdiction point is an interesting one, though, because, of course, there is a potential witness there, although this one wasn't in contact. But I know that in other cases that I've got, there are witnesses who've moved abroad, or they live in France, for example. What are your thoughts on jurisdiction? How we approach that?
Well, the starting point, it seems to me, is that if a witness is abroad, they can't be compelled to attend to give evidence at a coroner's court in England or Wales.
Yeah.
So that's the starting point. But it doesn't mean that they can't give evidence because they're abroad. It will be well known to our listeners that witnesses, both expert and factual, give evidence from abroad routinely via links, the CVP. And that should be the starting point. If a witness is abroad, it shouldn't be assumed, oh, well, we can't get him or her to give evidence. Starting point is, whilst they can't be compelled, steps should be taken to ascertain their willingness to give evidence.
I think in the case that we did involving, there was a chap who'd moved to New Zealand.
Yes.
As I understood it, there had to be contact made with the Foreign Office to understand what you can broadcast and what medium you can give evidence via. And I think in that case, it was actually getting him into the room that was the difficulty.
Yes, there was a marked reluctance, I think it's fair to say, in that case, on the part of the individual concerned to give evidence at all.
Yeah.
And I mean, that is really difficult to overcome. If you have a witness who just will not cooperate, then unless they step foot back in the jurisdiction and can be served with a summons, it's not a great deal that can be done.
And that it can be helpful depending which IP you are, because for the evidence to be read, and you can read it, there are provisions within the coroner's rules that would enable the coroner to read that evidence. But sometimes it contains information that's unhelpful.
It does, it does. So we've spoken a bit about preparation for a PIR. I mean, certainly my approach is that it's almost invariably the case that I prepare a short note for the coroner
Yes.
in advance of the PIR, just summarising. So it's not even skeletal. It's much less substantial than that. It really is just a note to assist. This is what we consider to be the scope. If there's an issue about Article 2, you can address that. This is the expert and factual evidence we would like, with short reasons for it. Whether a jury needs to be summoned. And in fact, in this case, it wasn't mandatory for a jury to be summoned. What did the coroner do about that?
Just dismissed it outright. Yeah. But I think the idea of a note is a really nice one, because it takes the confrontation away immediately. The coroner can then see what your approach is, rather than coming into it without knowing what's going to happen. The coroners ultimately want to help the family understand the process, if you're for the family, but if you're for a different IP, they also want to make those witnesses feel like they are able to give their best evidence. It shouldn't be about confrontation. And that there have been a few inquests recently that I've experienced where barristers have said, I put it to you.
Yes.
And that's not appropriate in the coroner's court.
I mean, you still see at final inquests, that's the approach. Forgetting that there are no parties, there are no pleadings, there is no cross-examination, and it's advanced as litigation. Yeah. Whilst I can understand that you properly represent your client's position and you put that position, it isn't adversarial, and the majority of coroners will say, or should say at the outset, these are not adversarial proceedings. It is inquisitorial, and we are there to help the coroner complete his or her investigation,
and to get the facts out.
Get the facts out.
That's the key.
Absolutely. So no jury. You mentioned issues of costs. I'm assuming that there's no legal aid.
No legal aid
for this inquest.
No, so it's a CFA. I was representing the family, so it's the solicitor with a potential clinical negligence claim at the end will take a CFA or enter into a CFA if they think there are sufficient prospects. And so it's on a CFA basis. I think as I received the brief the day before, I didn't really have much chance to assess the prospects, but those are the means. And also that's an important consideration in respect of what costs are going to be recovered, because if there have been admitted breaches beforehand, then on a CFA, you wouldn't recover the cost of attendance where those breaches are considered because they've been admitted.
And what then are the grounds upon which you could recover at a subsequent civil claim the costs of family's representation at an inquest?
Well, I mean, you would have to think about issues of causation. Value wouldn't come into it, so you couldn't argue it on the basis of quantum. And quite often, though, when I go to an inquest, it will be on the basis of, I think there's something there, and I think there's more that needs to be investigated. And then that comes out during the course of the inquest. And then ultimately there is a claim at the end. What is really troubling is when you have, and I've had it when I'm sitting, I've had a family unrepresented and legal representatives for the other IPs, and there is obviously a claim there. But because they don't understand the process, they don't understand the questions and how to approach it, the case is closed down. And that's a really big missed opportunity. Not even about, well, we'll have a claim, but also about learning. And this, how do we progress and evolve, trusts and health boards?
Well, that's extremely helpful, Sarah. Thank you for that. And that concludes this podcast. But can I, on behalf of Sara and me, again, thank you for listening, and say that if any issues or questions arise from this podcast or the subject matter of that we've been considering, please do get in contact with us in Chambers, and we'll do our best to try to assist. So with that, I'll say goodbye.
Thank you.